The Supreme Court's relentless push to restrict voting rights threatens to transform this fundamental democratic right into a limited privilege. On the 60th anniversary of the Voting Rights Act, the legal protections that once safeguarded this right are being systematically eroded, making it increasingly difficult for voters and their advocates to challenge discriminatory practices in court. Courts have historically served as a vital public forum where individuals could confront injustice and hold powerful entities accountable. For decades, they played a crucial role in ensuring equal access to the ballot box, striking down racial gerrymanders and discriminatory voting laws. However, today, it feels as though these courts are being closed off to the public, with some areas resembling permanent no-go zones. The most significant blow came in 2013 with the Supreme Court's decision in Shelby County v. Holder, which effectively dismantled the pre-clearance provision of the Voting Rights Act. This provision required states with a history of racial discrimination to seek federal approval before implementing changes to their voting laws. Chief Justice John Roberts argued that the blight of racial discrimination in voting had largely been addressed, a conclusion many found premature. In her dissent, Justice Ruth Bader Ginsburg famously compared this decision to throwing away your umbrella in a rainstorm because you are not getting wet. With pre-clearance gone, the court is now targeting another critical aspect of the Voting Rights Act. One major area of focus is the ability of private citizens and civil rights groups to challenge racially motivated voting practices. If the court adopts the stance of the Eighth Circuit, only the Department of Justice would be permitted to bring cases under Section 2 of the VRA. This shift would severely limit the avenues available for individuals to seek justice. But the court's assault on the VRA does not stop there. In a recent move, the Supreme Court issued an after-hours order just before the VRA's 60th anniversary, signaling its intention to reconsider the constitutionality of Section 2 and its ongoing relevance. This decision could have far-reaching implications for the future of voting rights in the United States. Compounding these judicial challenges, the Trump administration's Department of Justice has shown little interest in enforcing voting rights. The DOJ has reduced its staff in the voting rights section, backed away from key cases, and even considered prosecuting election officials, a move reminiscent of Project 2025's agenda. These actions create a hostile environment for those seeking to protect voting rights. Meanwhile, the executive branch is pushing forward with proposals that would make it even harder for Americans to exercise their right to vote. For example, the SAVE Act, which is currently pending in the U.S. Senate, would require specific government documents for voter registration, disproportionately affecting millions of Americans who lack access to these documents. These measures are justified under the guise of preventing voter fraud, a problem that does not exist at any significant level in the United States. Even before these new proposals, courts had already made it increasingly difficult for individuals and civil rights groups to challenge discriminatory voting laws. The combination of limited access to legal representation and a hostile judicial environment leaves bad actors free to suppress votes without fear of consequences. The situation is exacerbated by the administration's attacks on big law firms, which often provide pro bono services for underrepresented groups. Over the past 2 decades, as the Supreme Court has chipped away at the Voting Rights Act, voter suppression has evolved into a more subtle and pervasive issue. It now relies on complex administrative hurdles, confusing rules, and constant changes, making it harder for citizens to vote without facing significant obstacles. The aftermath of Shelby County versus Holder is a prime example. Within 24 hours of the ruling, Texas reinstated a strict photo ID law that had previously been blocked due to its discriminatory impact on Black and Latino voters. 2 months later, North Carolina passed a law that reduced early voting, eliminated same-day registration, and imposed strict ID requirements, all of which disproportionately affected Black voters. the Supreme Court's decision in Brnovich v. Holder, DNC further weakened the Voting Rights Act by making it more challenging to prove racial discrimination in voting laws. This ruling gave states greater leeway to implement restrictive measures, even if they disproportionately harmed voters of color, as long as they claimed to be preserving election integrity. Georgia's SB 202, passed after the 2020 election, is a case in point. This law, which includes provisions like a ban on food and drink at polling places, has been shown to disproportionately impact black voters, a trend that aligns with the Brnovich ruling's weakening of Section 2. The situation is even more alarming, given the current purge of nearly 500,000 voters in Georgia, one of the largest in U.S. history. New analysis suggests that when out-of-state movers are removed from the rolls, black voters are disproportionately affected, raising concerns about potential discrimination. The recent federal appeals court ruling that only the U.S. Attorney General can bring Section 2 lawsuits further erodes the legal tools available to protect voting rights, leaving the DOJ as the sole enforcer in most cases. 60 years after the Voting Rights Act was signed into law, the Supreme Court appears determined to ignore its legacy and dismantle the legal framework that once protected the right to vote. While the John Lewis Voting Rights Advancement Act, reintroduced by Senator Raphael Warnock, offers a path to restore some of the VRA's protections, it cannot fully address the damage already done. Ultimately, the burden of protecting democracy should not fall on individuals. Voting is a right, not a privilege or a test of endurance. On the 60th anniversary of the Voting Rights Act, we are moving closer to a future where justice is out of reach for those who need it most.